contract basics. What is a contract? I've seen people, my clients, have the widest possible conception of what a contract is, but if you really want to get the most out of your contract, your dealings with your lawyers, to the extent that any of you do deal with lawyers, you should consider the contract to be an operations manual. It's basically something which, after you've done with it, any other senior person in your company or somebody at your level, perhaps even your replacement if you're intending to leave, should be able to come in, pick up the contract and understand what this deal is about. So fundamentally it should be written in simple language. It shouldn't be, not a whole lot of herewithals, heretofores and therefores and that, but simple English, plain stuff. Anybody should be able to make sense of it. There will be legal terms, obviously, which you may not quite understand the impact of, but you should be able to ask sensible questions of your lawyer based on what you read. It's basically a tool to allocate risk between people entering into business. Now, the way you allocate risk can be done in a number of ways. One is for having the sort of clauses which say, you won't be liable for more than X amount. And also simply by saying, you will do this, I will do this. That itself is a very effective risk allocation, because it makes it very clear that if anything happens with what you're saying you will do, that's your responsibility up to a certain amount. It should also, because in a service provision, which is increasingly getting more complex in a more complex industry, you will almost certainly have situations where things change. What you originally were meant to deliver may not be what you end up delivering. There will be things you will need to change with your client or with your service provider, as the case might be. So the contract has to have certain processes, which are just ways for both parties to deal with changes, with meetings. How do you deal with problems? And I'll get more into that later. What the contract's not useful for, what you really should not use it for at all, and you'd be surprised how often I see this, is it should not be used to state general principles that, for example, X will provide services, which is great, but really means very little. You want to say quite clearly what sort of services you're going to provide. It's not the place to put aspirational statements. So very often in contracts you'll see things like, X and Y have decided we will work together to develop this wonderful game which will thrill X and Y audience and sell X amount, whatever. That's all very good. It's great in a marketing brochure. It's great when you start discussing, as a sort of entry into commercial discussions. It has no place in a contract at all. The contract is something where whatever you have in it should be quite precise, clear, and to the point. And if you can't put something as precise as that in the contract, then maybe you should take a step back and really think about whether you've reached a state where both parties really know what they're doing. The other thing that comes up quite often in a contract, and that's perhaps more of a personal view, is that people seem to think that they've got themselves into a good position in a contract if everything is in your favor, or as much as is in your favor as possible. And I can see why this would seem attractive at first, but really, you're much better off in a contract with the other party if the contract is as fair as possible. Yes, you should pay attention to things which really cause a problem in your business, to risks which you're asked to take which you can't manage, which you think are unfair that you should manage, that's fine. But where you're being almost argumentative and you want to win a point just because you want it to be in your favor, but it doesn't actually do you much practical good, you should think about whether that's actually worth it in terms of having a long-term relationship with your client. The what and hows. The reason I distinguish between the what and hows is that the whats are what I call potential time bombs. These are things which have the potential, if you have a problem, they can potentially destroy a working relationship with a client or actually prevent it from ever getting off the ground. So time bombs absolutely need to be diffused by contractual certainty. And what I mean by that is, at the time you sign the contract, you do the deal, these are the terms where there should be as much clarity as possible. You don't want to have to go back and say, oh, we didn't really realize this or that and we want to change this. These are services, deliverables, deadlines and money. Straightforward stuff. This is what you're in the business for. What service are you providing? In what form? How much money? When? These are things you've got to get clear at the outset. Pressure points are things which are also important, but which, if you don't get absolutely right, or if you don't absolutely nail them down at the very outset, they will cause friction. But in my experience, these are things which can be solved even during the working relationship. So what you've got to ensure that, to the extent that you can't be completely specific at the outset, you've got to have mechanisms in the contract which at least deal with them, processes. So, service standards, service levels, employee matters, I'll explain what I mean by that, and testing and acceptance. That's actually the most common one I find, where at the outset, for quite obvious reasons, you're not quite sure always what a project entails at the very outset when you sign the contract. You're not always sure about the extent to which testing has to happen. Sometimes you are, but to the extent that you're not, you must at least have a process that sets out what is all this about. Let's talk a bit more detail about these issues now. Services. And we'll talk about each of these issues from the point of view of the supplier as well as the client. So you can, what I'm hoping you'll see is that actually the things that you need to get to in the contract are in both parties' interests. And that's, if there's one lesson you should take from this talk, it is that. So in terms of services, what's the supplier want? The supplier wants to know, what do we do, and what do we need from you, the client, in order to be able to do it? Because often you've got dependencies. And the reason I put the pound sign there is just for money, even though we're going to talk about money separately, but just to impress that this particular term, if you don't get it right in the outset, has huge financial implications potentially down the line. Especially in a relationship where it's the first time you're dealing with someone, first time you're dealing with a service provider, or it's the first time you're doing a job for that particular client, you need to pay a lot of attention to this. From the client's point of view, clearly, the client is concerned with making sure that the contract sets out what do we need to be done for us, what if we need more things, different things, can we do that? And who's going to manage all of this? Do we need to make sure we give you someone to manage it, or will the service provider have somebody who deals with the project management time? So, for both of you, what you really need, whether you're a client or a service provider, you need detailed written specs on the services. Exactly what are you providing? And if you're providing a number of services, so for example, if you're talking a framework agreement, where you're basically agreeing an overarching commercial relationship with somebody and saying, over the course of the next 1 or 2 years, we'll just call off services as and when we need, that's fine. So obviously that particular framework agreement can't be as specific as you'd like it to be. You have the work order, the project schedule, whatever you choose to call it, that's going to have the details in it. But even then, what the framework agreement should have is at least a list of those types of services which you've agreed. So if, as a service provider, you're going to do some QA work, localization and what have you, there's no point suddenly the client coming and saying, well, actually, we'd like you to do some original development of IP as well. And you never said you couldn't do it. I've actually seen this happen. So it's well worth your time, where it's going to be a framework agreement, set out a clear list that you, the client, can use any of these services, but that's it. And the details will be set out in the particular work order. Deliverables. As I said, from the supplier's point of view, you need to know what you need to deliver and in what format. Very often I've seen, especially at the beginning of a relationship between two companies, that people are in such a rush to get started sort of working on the project that not enough time is paid to the format. And I've actually seen timetables being set back by months on end sometimes because somebody hasn't paid attention to agreeing what exactly the format is. Now, for big projects, consoles which need extensive QA, this, that, and the other, that's not likely to be a problem. But there is a lot of much smaller scale work going on where you can cause serious problems if you don't set this out very clearly. So both for the client and the supplier, you need to make sure the contract sets out very clearly what format, what deadline, and that's it. Deadlines, let's talk a bit more about that. It's another thing that causes a lot of problems. From the supplier's point of view, you need to be very clear that you know by what time does your client need this. And it's no point thinking, oh, we'll figure it out as we go on, as we see how extensive it is or how long delivery might take, how long development might take. You need to make sure you've got a long stop date, because it typically can really spoil a working relationship. If the client thinks you know when it's to be delivered, or if there's any misunderstanding about this, this is a very serious issue. And you will be well off, especially as a service provider, making sure whether those deadlines relate to pre-testing or post-testing deadlines. Very often I've seen this, where there is a lack of certainty whether delivery means delivery of the accepted product or delivery of the product to be tested. It seems obvious, but it's very often forgotten. From the client's point of view, most clients will say we want it ASAP. And that's usually been the case where it's a very commoditized product and the service provider doesn't have much of an input. So, you know, sort of the old model. But more and more, I think, as in IT outsourcing, the clients are quite happy to listen to the service provider and make sure that the date you agree is a reasonably achievable date. Now, what I mean by that is a date which neither party thinks, well, this is a real risk. There's a real risk of missing this date, because that again is a real issue. You don't want that. And the point that I'll keep making throughout this is that be reasonable in the contract. Think about what you can or cannot do, or even think about what you're asking the other party to do for you. If you've had other service providers who are not able to deliver those deadlines, how likely do you think it is that one service provider will be able to do it if nobody else can? So really do think about this. And you also need to think about what happens if there's a delay. With the best will in the world, unexpected things happen. You can have all sorts of provisions in the contract, like force majeure clause, etc., which I won't bore you with now. But a delay is a delay. What do you do? What is the mechanism you use to inform the other party? Is there even an obligation to inform the other party? I've seen many contracts where people don't even expressly make clear to the service provider that, look, if you think there's a delay, you've got to tell us as soon as you think there might be a delay, and not when delay is actually unavoidable already. So always try and think a couple of steps ahead. Just to put yourself in the position, if you're a service provider, put yourself in the position of the client and think, if you were paying somebody to do this work for you, what would work for you? What would you like to see in that document? Money. Again, one of the biggest time bombs, really. As a supplier, you want to make sure that all the possible charges are already set out in the contract. When I say all the possible charges, it really relates to more people who provide a range of services. The last thing you want to do is go back to your client halfway through a contract and say, oh, sorry,